Welcome back. The time is 22 minutes past 9, and you're still tuned in to Salam Media. In this hour of news and views is proudly sponsored by Africa Muslims Agency. Africa Muslims Agency, a beacon of hope to communities for over 35 years in Africa and beyond. And with that being said, yesterday at the Lichtenberg Magistrates Court, Johannesburg resident Ziad Hurzuk, who I'm sure by now you should be familiar with the name and the case, he's accused of funding terrorism through cryptocurrency. He faced another delay in his bail application due to a power outage. Hurzuk who's alleged to have transferred Bitcoin to a Syrian charity with alleged ties to terrorism back in 2017. This case is seen as a test for South Africa's commitment to exiting the Financial Action Task Force grey list, and has garnered significant attention. And to provide us with an update on the proceedings and the implications, we are joined by attorney Yousha Tayob, who has been closely involved in the case and has joined us on the show before, and is going to be giving us the latest on that regard. Yousha, Jazakallah so much for joining us. Welcome to Salam Media again. Really appreciate you giving us your time.
Well, Assalamu alaikum wa rahmatullahi wa barakatuh. My pleasure.
I think first and foremost, could you start by just updating us on what transpired in court yesterday and why the bail judgment has been delayed?
Yeah, so yesterday wasn't the only power outage. You'll recall that when we brought the bail application on the 10th of January, the court started late and we were affected by a 2-hour power outage. That happened again when we raised argument on the 15th of January 2025. And what happened yesterday was that the magistrate indicated that as a result of those power outages, the transferring of the recording to his laptop had somehow been compromised, so that he wasn't able, in the period between the 15th of January and the 22nd of January, able to access the recordings. And he accordingly indicated that he would need until next Tuesday, the 28th of January, to finalize his judgment, because the recordings were compromised on account of the power outages during the bail application and the argument. So it's been postponed to the 28th of January, next Tuesday, for judgment on the bail application.
I want to touch a bit again on the allegations and you being part of the defense. Hurzuk has denied funding these terror activities, stating that the recipient of that Bitcoin transfer, Al Sadaka, was not listed as a terror organization at the time. Could you elaborate a bit further on this aspect of the defense and the evidence supporting that fact?
So the issue is that he made this transfer in 2017 when there was a call for funding for Syria, for humanitarian aid. And at the time, we have the concession from the investigating officer that this organization, Al Sadaka, is not in fact on the terror list. There's an e-wallet into which the cryptocurrency was transferred to that was listed by the USA, and the list was transferred to the UN, who simply rubber stamp the US applications. We also know from the evidence that the police, in fact, investigated a 75 Rand transaction, interviewed the suspect in that matter, established for their own that was an innocent transaction, that the donor did not know that those funds were transferred to an alleged terrorist organization, and did not prosecute that matter. But they seek to prosecute this matter. We also have it on record that there is substantial political involvement in this matter, and we hope to uncover that during the course of this trial. And also a concession from the investigating officer that he in principle had no opposition to bail, but that his brigadier had instructed him to oppose bail in the matter. And we have no doubt that those as from previous experience, somebody's pulling the strings somewhere to make sure that this persecution proceeds.
Are you able at this point to give us any, or maybe just elaborate a bit further on that, the political interference in this case, no matter how brief, whatever you can give us from what you guys have found out?
Well, so, the offense allegedly was committed in 2017. We now have a concession that the recipient organization is not on the terror list. They rely on the legislation that says he intentionally gave money to a terrorist organization. We now know it's not a terrorist organization, nor does it appear on any list. And that's why I refer to it as a persecution as opposed to a prosecution.
Mm.
We have a concession that somebody who donated 75 Rand to a confirmed terror organization has not been prosecuted. So the police and whoever is instructing them have a whole lot of explaining to do. We have a concession from the investigating officer that he's been in the anti-terror unit for 5 years, that he's received training in the USA, but that he has absolutely no expertise on terrorism or the conflict in Syria. So, one need only read between the lines to see that this is in fact a persecution as opposed to an independent prosecution. To my knowledge, even in the Gupta matters, the head of the NDPP did not sign the charge sheet, from what I saw. But in this particular matter, the head of the NDPP herself has signed the charge sheet, which indicates to me that there definitely is an interference in the matter. And if we can recall a few years back with the matter in Kagiso with the Patels, I was literally at the Kagiso police station, and the bail papers had been prepared and ready, and it was just a matter of signing it and paying the bail when the prosecutor in that matter received a telephone call and then returned to the office and said to me, "No bail, see you on Monday in court." And this matter is beginning to stink of that kind of interference as well.
Mm, 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 mm. No, very, very concerning, outline that you're making there. One thing that sticks out is the fact that this case has been described as a test for South Africa's handling of cryptocurrency-related offenses. How do you view the legal framework and the challenges it presents in proving or maybe disproving Ziad Wurzuk's intentions with that Bitcoin transfer?
Well, this is the difficulty the state has. One, it's already conceded that it's not a terror organization. Two, we know that the U.S. Arranged for this e-wallet account to be frozen and declared a terrorist organization. He admits the transaction. We have shown substantial evidence over the years that he has complied with his religious obligations in giving charity, and this was his charity. We've also through the proceedings established that he never had any intent to support an alleged terror organization. He was simply giving a charity. We've shown that over the years since 2017, he's continued to give charity to various organizations. We've given a copy of the bank statement for 2024 showing all his charitable donations. Sorry, there's one thing that slipped my mind. In fact, on the issue of intention, and you raise it, there was never an intention, and the state's going to have a hurdle in proving that. And just so you know, I mean, this e-wallet appears on some UN list numbered as number 79 of 155, and how any layperson could have access to any such information is beyond me. And the state will have to prove that he knew, intended, or reasonably ought to have known that this was a listed entity. They rely on an advertisement in the warrant when they executed the warrant, which they then tempered with in the bail application not to reflect the date of June 2019. And we have it on good authority that this organization, Al Sadaqah, only joined social media, Twitter, in March 2018. So none of the dates and facts are tying up to the allegations that the state makes. And we've put all this up in our affidavit. We've cross-examined the investigating officer on it, so it's all there already. And
Mm.
if this is what the state relies on, we have a substantially good defense at this stage.
Mm, mm, mm. The Financial Intelligence Center, and I think for most part, law enforcement, they appear to be using this case to demonstrate, South Africa's commitment to combating terror financing. Do you feel this adds undue pressure or bias in how the case is being handled currently?
Well, so that's what they say in the papers. They say this transaction is the terror financing, and there was a statement by the Institute of Security Studies yesterday to say that once this case is successfully prosecuted, we will be removed from the grey list. But we know that there are substantial other terror funders in this country against whom nothing is being done. So, how's Yad Hurzouk's case and a successful prosecution, which I doubt will happen, is in fact not going to change anything because the allegations are unsustainable in regard to the facts we have and the dates and the information we have. And also, I mean, the purchase of the Bitcoin was done via his local account. The Bitcoin was then transferred electronically into a crypto e-wallet. It's all traceable. If somebody wanted to terror finance, if somebody wanted to hide, none of this would have been done in the way he did it. So the conduct belies the allegations because it's all traceable.
Mm, mm, mm. What would you say have been, some of the biggest legal challenges in this case so far, especially considering the fact that there's an almost evolving nature of the technology and the regulation of cryptocurrency in South Africa. There's no base laws around how it is used and the legal framework around it also.
So you will have noticed, by the way I look, I'm an old fellow.
Mm,
Bitcoin and cryptocurrency and all these new advancements. I'm not entirely on top of it, but in essence, they all are traceable. So whatever you do, whether you buy a Bitcoin, whether you transfer the Bitcoin to a crypto, it's all traceable. And insofar as intent is concerned, they're going to have substantial difficulty in showing that he tried to hide a transaction or that he tried to fund a terror organization. He was simply giving charity as he's obliged to do in terms of his religious beliefs. There was a call for assistance. Syria was in civil strife, civil war, and he responded to that call as he does on an almost daily basis in his charitable contributions. So, at this stage, it doesn't seem to me that there was any intent, certainly to hide the transaction. It's all there's a paper trail. He's admitted, based on the evidence presented by the state of the transfer from his own South African personal bank account to purchase the Bitcoin to pay the money into an e-wallet that he believed to be for a charitable humanitarian cause. So, we still have to hear from the experts. They keep talking about experts that they intend to bring, but in the bail application, no such evidence was given. It was alluded to. Substantial atmospheric allegations were made against him, that he had information about Al Qaeda, articles about Al Qaeda and ISIS on his phone. Those are not offenses, but it
mm,
was there to address the atmosphere. And in fact, at one stage, the prosecutor, in trying to convince the magistrate not to grant bail, indicated that Ziad Hurzouk, on account of he's now being charged, he'll be in custody tonight for 21 days, 21 nights, is a hero in Syria. There's no evidence.
mm,
The argument by the prosecutor was completely baseless. He talked about 6 stages of investigation by the NPA, and that the state's case is not weak, and because of these 6 stages, the case is great. At that point, I almost wanted to say to the magistrate, there's really no need for you. If the NPA prosecutes someone, just convict and sentence. Well, why do you even want to go through the process? They refuse to concede that their case is weak. They don't have any evidence. In fact, they say to the contrary, that Al Sadaqah was they accept was not on Twitter in November 2017. They rely on an ad that is dated June 2019, calling for jihad. They take a completely myopic view of jihad. They don't understand it. They only believe it to be what the West wants them to believe it to be, which is the violence associated with fighting oppression, which we're obliged to do, compelled to do. I think they have substantial difficulty, but they keep referring to experts and other evidence that they intend to bring, which we will not have sight of until a trial date has been set and copies of the contents of the docket given to us. So we wait. I mean, first prize for us now is bail. That's our urgency. And after bail, inshallah, we will get the docket and we will be able to assess the evidence. It can't be substantially more than they've already given us now. So based on what we have now, I'm quite confident that we have a defense that should succeed.
And just two last questions before I let you go. How is Ziad right now? Number one, and number two, finally, beyond your client's case, beyond this case, what do you think this trial could mean for future cases involving cryptocurrency and allegations of terror financing in South Africa? We are heading to the holy month of Ramadan. We know a lot of Muslims will be giving charity to a lot of organizations from different parts of the world. This case specifically, what key lessons are there to be learned from it?
So look, in essence, it's never a nice thing to be in custody. He was very strong in the period from his arrest until the 15th of January. On the 15th of January, when the magistrate postponed the matter for a week, you could see his shoulders drop, his body language. It's obviously not a nice place to be in a holding cell, being kept when you haven't done anything wrong and you know that in your mind. So being detained unlawfully must have its impact. But he's mentally strong. He's just irritated by the fact that he's being persecuted literally, and I've used that word a few times. Insofar as future donations are concerned, and I've said it before, we as Muslims have religious obligations, and we must continue to pay those religious obligations in whatever form we need to pay them. In fact, we must double, triple our efforts because of the need of Muslims locally and internationally. South African Muslims have been known to support charitable causes all the time. We have many established organizations. And so, I don't see a difficulty. And if anybody is persecuted in the future, I myself and the Muslim Lawyers Association and my current team, will do whatever we need to do to show that these are not related to terror financing, and that the legislation is designed to persecute. So we must continue. Sorry, you asked the third question.
Yes. Some of the key lessons that could be learned from this case.
Yeah, look. So I mean, the point is, he's made a transaction. There's nothing to learn. There was a call for charity, and he responded to it. We have an obligation to distribute our charity to causes we believe in, and causes that need our money, whether it's in the form of zakat, sadaqah, or lillah. And the point, quite simply, is he did what he thought best in that circumstance when there was a call for funds. And so everybody has their own discretion. But I think hopefully through this case, we will be able to establish that their myopic definition of jihad needs to change quite quickly. And they need to understand that copying and pasting laws from the US and other Western powers into our law doesn't fit, because if we're entitled to what they call freedom of religion, or what everybody calls freedom of religion, then we're entitled to give our charity as we are entitled to do. And if it's for whatever jihad purpose, the one who funds the fighter is as though he has fought. So the issue is really our religious obligations are bigger than any other obligations we have to any country or state. our
Mm.
loyalty to and obligation to Allah is complete. There's no half measure here.
All right, I think we're going to leave it on that note. Thank you so much, Yousha, for sharing those insights. And I will definitely be continuing to follow the developments of this case quite closely. But we're going to leave it here for now. Jazakallah so much.
Jazakallah. Assalamu alaikum wa rahmatullahi wa barakatuh.
Oh, there you have it. There was Attorney Yousha Tayob, and he was giving us the latest on, that very, very important case, very, very complex case, where Ziad Horzuk has alleged to have transferred Bitcoin to a Syrian charity with alleged ties to terrorism. And this is back in 2017. So yesterday at the Lichtenberg High Court, his bail application was postponed due to, well, a power failure. So, yeah, we'll be following this case quite closely. I think it's important because it highlights not only the complexities of financial crime in the digital age, but also you can call it the intersection of humanitarian efforts and legal scrutiny. And I think it will be very, very important to follow it through, and we'll continue to do that closely. Not just to learn from it, but I think for you, our listeners, Ramadan is around the corner. As Yusha said, there are religious obligations that need to be met. And I think this case would be a perfect case study of how you can go about your business to make sure that, you don't find yourself in the same situation, because the laws and regulations around cryptocurrency, unfortunately, in South Africa are still not cemented. We're still trying to figure it out, and that poses a lot of challenges of what you can do and can't do when it comes to cryptocurrency and the transaction thereof. We're going to take a quick break. When we come back, we'll be shedding light on the DRC after the short break.